Our today's lecture is on scope of practice in NRI Matrimonial dispute, and our today's guest is celebrity advocate Mrunalini Deshmukh. She is practicing advocate and practices in family court matters, and she also delivers lectures on this topic in India and also in abroad. So I am requesting you all to take benefit of her expertise and utilize her expertise in your daily life. So let us welcome our today's guest, Advocate Mrunalini Deshmukh and Advocate Rahul Maskar. I would request Advocate Rahul Maskar sir to felicitate our guest with Tulsi.
Oh, thank you so much. Good evening, everybody. It's indeed a great pleasure and honor to be here, especially where lectures organized by the Hammurabi tablet is there, and their catchword is quench for thirst. In today's materialistic age, most of us are lawyers here. Most of the professionals have a quench for money. They have a quench for materialist things. But someone like Rahul has, and his team of course, have a quench for, as they call it, for the knowledge, which is the most important thing. But before I begin this, I need to apologize to all of you to keep you waiting. And maybe it's a cliche thing, but these are really circumstances beyond my control. I left at the appointed time. I think the traffic of Mumbai took the better of me, and that's the reason I'm extremely apologetic for keeping you all waiting. I know what it means on a Saturday evening to be waiting for some speaker to come when you want to wind up for the week and go back home. So my apologies. So it's a very interesting subject that Rahul asked me to speak about, and that is more importantly as what are known as the NRI marriages. Now, as I understand, why is this a concept so relevant in today's time, and why is there so much of even uncertainty about it? So like it's a combination of having a lot of uncertainty, at the same time there is a lot of issues which are of relevance in today's times which are there. Now if you go back to the Hindu Marriage Act, which was the codification done in 1955 Act, which is there, I'm sure the legislators never thought of such a situation that would arise, and that is why there is no specific provision made in the Act as we see regarding the same. So where does the law come up from, and how and where do you find the origin of the law as far as the NRI marriages are concerned? At the outset, let us first understand what is an NRI. An NRI marriage is that marriage where there are two Indians who get married, but one of them is a resident of India and the other one is a resident outside India. So this is a combination which they get married. Most of the times, I would say 90% of the times, it's the husband who is resident outside India and the wife who is resident in India. So what happens is that they get married. Most of the marriages are arranged marriages or love marriages or whatever case may be. These days there is a lot of Shadi.com marriages and online marriages and so on and so forth. Anyway, all said and done, the parties get married in India, whichever their hometown is, as per the Hindu rites. They get their marriage registered, and typically what happens is that the wife does not have a visa to follow her husband in terms of employment or in terms of dependent visa or whatever the case may be. So there is a waiting period which is there, wherein the wife continues to live in Mumbai or India for that matter, and the husband goes because he has to join back. So they go on a honeymoon, they do some little things in India, then he has to go back with an understanding that she will join immediately. The question is, there are genuine difficulties sometimes in getting the visas, and that is why the delay is there. And on other occasions, there is no intention to get the spouse there. So there are these two issues which come up as far as these NRIs are concerned. Now the question that arises is that under such circumstances, what happens if the person who is resident outside India, and I am just taking US as an example because it's true for all countries, but for us to have one specific example, let us say the wife is in India and the husband is residing in the US, and lack of communication or whatever that transpires in that intervening period, the husband wants a divorce or does not want to continue with the marriage, then what happens? He is able to create a jurisdiction of the court purely based on the residence. So he is an NRI, he is not a citizen, but if he has residence in certain area, for example on the East Coast, if you go to Boston, etc., 6 months of residence gives you the right to file a petition in that court. Now what happens is, under these courts and most of these US divorce cases, is there are 3 types of divorces. So divorce is a no-brainer. I mean, nobody contests divorce there. The judges don't have to sit and decide what a divorce is. So divorces are on 3 grounds. Number 1, in the US, the divorce is what on some states, because these are federal states, so they have their own respective thing. So some of them have what is known as a no-fault divorce. So what is a no-fault divorce? There is no fault of yours, literally. But I don't want to live with you, or I'm out of love, or whatever. And that is the reason. So I'm not making an allegation you are X, Y, Z, you're bad, you're good, whatever. But this is what it is. The second one is on the irretrievable breakdown of marriage. We've been living apart for 2 years, 10 years, whatever the number of years is. There is no cohabitation between us, and that is why we have to get divorced, or irreconcilable differences. And on these grounds, a husband, I'm just taking husband as an example, can get a divorce in this. What is the procedure? The courts will say, please issue summons to her. Now, how are the summons issued to her? Either the summons are issued to her through say courier, or summons are issued through a solicitor of the US to anybody who, if it's their counterpart here. Because in US, the process of summons served is similar to what we have in India, which is known as a bailiff. What they call there is a process server. So for example, a law firm appoints Mr. X as a process server. He has to go and take the copy of the petition, and it's very strange. It says it should touch the body of the respondent. So you can't just throw it under the door or throw it on the top and do it, okay, the service is done. It has to touch the body of the respondent, and I'm saying respond for the other side, and then he files an affidavit in the court to the penalty of perjury and all that, saying that I had served this copy of petition on the respondent at 7:30 in the morning at her place at this time, this, etc., etc. Nowadays, of course, we have phones and also we can take pictures and things like that. Once that process server's affidavit is on record, then it is deemed to be, the respondent is deemed to have been served duly as per the process of law. So this is if the respondent is within the limits of that particular court. If the respondent lives outside, then under such circumstances, obviously it's the courier or the Indian consulate and all other modes, which I don't need to get into. All of us are familiar and aware of that, of what the different modes are. Typically in a situation like this, the woman who is trapped in a situation does not have the resources to fight a divorce in India. Number 2, she does not have the wherewithal to find a lawyer to represent her there. And thirdly, there is complete lack of knowledge. I mean, what do I do? I mean, there are people who come to me and say, oh, this is, I've been served by my husband. Now, what do I do? And I'll tell you today, this morning's case also, but which is the other way. I'll let you know that. And what do we do and how do we go ahead with it? The courts there give an ex parte order, provided there is an affidavit of the process server which says that the summons has been served upon the person. And that ex parte order, armed with that ex parte order, the husband now comes and tells, listen, sorry, you are no longer my wife. This is a court of competent jurisdiction who has granted me this divorce, and this is the decree of divorce. Now we are not there. Certain courts may not even give alimony. Certain courts may give a very paltry sum as an alimony, because most of the times a divorce decree without an alimony is considered to be not 100% valid decree, because there has to be some provision for an alimony or maintenance. But this is again a very subjective rule, a subjective ruling as far as the judge is concerned. Now, having said this, the fact of the matter is, under such circumstances, what happens? Now, this was happening if I go to India, primarily in the north in Punjab. Now in Punjab there were a whole lot of these men who would go out in search of employment, business, etc., and then they would send these things which were there. So like Punjab had become the real problem of NRI marriages, if I may say so, originated in Punjab, because there were a whole lot of cases are there, and I'll deal with some of those cases which are there. And that is when the Indian courts were flooded with these petitions coming from these wives who were deserted, divorced, or whatever you may call them, asking them for maintenance, asking them to cancel the decree and do all this. That is where, through judicial activism, through legal precedents, and through the case laws, this law regarding what is the validity of a Hindu marriage and which is a court of competent jurisdiction to decide the dissolution of marriage came up. So the classic case in that was in the year 1975, where Y.V. Chandrachud, Justice Chandrachud was then at the helm of the affairs in Supreme Court, was Satya versus Teja, or Teja versus Satya, one of the two. In that case, similar thing had happened. They were married here, the husband went there, he got a divorce, the wife had filed for under 125 CRPC for maintenance, and the husband was served. Till then she didn't know, because he did not contact her at all. And then he was served, and when he comes and he says, what wife? She's not my wife, this is my decree of divorce which is there, and please accept this. Now she is no longer my wife, you have no jurisdiction, you cannot decide what maintenance has to be there. Sorry, too late in the day, and there is nothing which is there. So Satya versus Teja is one of the landmark cases, which is 1970, and I'll come to the ruling. Subsequent to that, in the year 1990 or 91, there was another case which came up, which was on the similar lines, and I think most of us know that. That is the case of Narasimha Rao. Now in Narasimha Rao's case, which came up in the Supreme Court, the concept of what is a valid divorce, which court is a competent court of jurisdiction to decide about the divorce issues arising out of marriages under the Hindu Marriage Act, and so on and so forth, was laid down. So if you permit me, I'll just read 2 or 3 paragraphs of the judgment, and which are so eloquent and which are so sort of, self-explanatory, and I think that will give us the idea. I've given you the background for you to understand what was the issue that was there before Narasimha Rao's case. Same issue, wife filed for maintenance under 125 or some other provision, and the husband comes and says. So after examining the divorce decree which was passed by the US court and looking at the facts of the circumstances, the Supreme Court rose to the protection of these women for giving them justice in the real sense of the word, and not to be left to the vagaries of other is a sort of the legal system which is otherwise there, that okay, there is a decree of divorce which is there, and now what can do. So I'll just read out what it said was in Narasimha Rao versus Venkata Lakshmi 1991 3 Supreme Court cases. It says only that court will be a court of competent jurisdiction which the act, that is the Hindu Marriage Act, or the law under which the parties are married recognizes as a court of competent jurisdiction to entertain the matrimonial dispute. I'll read again only for clarity. Only that court will be a court of competent jurisdiction which the act, the Hindu Marriage Act, or the law under which the parties are married, which was the Hindu Marriage Act, recognizes as a court of competent jurisdiction to entertain the matrimonial dispute. Any other court should be held to be a court without jurisdiction unless, what is that? Unless both the parties voluntarily and unconditionally subject themselves to the jurisdiction of that court. So if in a given situation both the parties decide that okay, I am living in Bombay but I want to I want to submit to the jurisdiction there, and I am okay with that court deciding, then the Indian courts need not bother, because it is not to the prejudice of any of the parties. Parties have voluntarily chosen to subject themselves to that, and that is what has happened. Subsequently, the courts in the subsequent paragraphs also states the decision of the foreign court should be on a ground available under the law under which the parties are married, number 1. what does it mean that it should be a ground available under which the parties are married? Now, those of us who have studied, and I am sure most of you all have studied Hindu Marriage Act, you have section 13(1) which talks about the grounds of divorce. You have section capital B 13(b) which talks about a mutual consent divorce. If it's a mutual consent divorce, you don't have to get into the nitty-gritties of it. You say we've been married for 1 year, we've been separated for over a year, and we've decided that we cannot live together, and so we want to do, our marriage has broken down irretrievably, there are no chances of any resurrection of this, and that is why kindly grant us a decree on the following terms and conditions. Fair enough. But if that's not a situation, then what happens? Then you have to prove your divorce. And you can only prove your divorce under one of the grounds that is available under the law, whether it's cruelty, adultery, desertion, unsoundness of mind, etc., which is there. Now, these are the grounds available for the parties married under the Hindu Marriage Act to be taken up as a ground for divorce in the event it is not by mutual consent. So, in this backdrop, please understand what the courts have said. The courts have said the decision of the foreign court should be on a ground available under the law under which the parties are married. So, where is the exception carved out? If the decision of the foreign court is based on, they don't call it cruelty there, they call it unreasonable behavior. If it's based on unreasonable behavior, which is either that could be physical violence, there could be mental violence, etc., then that could be considered as a decree which is akin to the grounds which are mentioned in the petition. Number one. Number two, the decision should be a result of the contest between the parties. So there has to be a contest. You can't have an ex parte order and say, okay, this is final and now you cannot do. The party should voluntarily subject, the parties should contest, and after a fair contest as per the rule of law, whatever order is there, that should be there. It says the latter requirement, that is, what is a contest? Very important. The latter requirement is fulfilled only when the respondent is duly served and voluntarily and unconditionally submits himself or herself to the jurisdiction of the court, contests the claim, or agrees to the passing of the decree with or without appearance. So these are all the four conditions the court has laid down. A mere filing of the reply to the claim under protest, or without submitting to the jurisdiction of the court, or an appearance in the court either in person or through a representative for objecting to the jurisdiction of the court, should not be considered as a decision on merits. So kindly see, so much of application of mind has gone in this judgment. They have tried to envisage every possible sort of situation that is likely to arise in a foreign court as far as this is concerned. And they have also laid down that this contest means a meaningful contest. This submitting to the court is a meaningful submission to the court. It doesn't mean that if I go and I say, okay, I am objecting to the jurisdiction of this court, that means I have submitted to the court. No, that is not considered to be submitted to the court. So all these conditions have been considered by the court. And lastly, now I will go to a number of cases which are there. The marriages which take place in this country can only be under either the customary or the statutory law in force. Hence, the only law that can be applicable to the matrimonial disputes is the law under which the parties are married and no other law. Means if you are married under the Hindu law, Hindu Marriage Act, your divorce should be as per the Hindu Marriage Act, contested or by consent, and these are the things which are there. When therefore a foreign judgment is founded on a jurisdiction or on a ground which is not recognized by such law, it's a judgment which is in defiance of law. Hence, it is not conclusive of the matters adjudicated therein and therefore unenforceable in this country. For the same reason, such a judgment will also be unenforceable as per clause F of section 13, since a judgment would obviously be in the breach of the matrimonial law in force in this country. So besides the judgment or besides the reasoning that has been given by the courts there, they have also referred to section 13 of the Civil Procedure Code, which talks about the effect of a foreign judgment, and all foreign judgments can be effective here, and there are exceptions which have been carved out, provided X, provided Y. One of the exceptions, which is clause F, talks about if it is not as per the law of the land. So under that exception is also one of the things where you can object to the foreign jurisdiction which is there. Now this was later came up in a very famous case of Sondur Gopal, Sondur Rajani. I am sure those of you who have studied this will come. I am just going through the landmark judgments because there are a whole lot of catena of judgments, but then that is not what the point is. What is different? Sondur Gopal versus Sondur Rajani, 2013, 7 SCC 426. In this, the husband had contended since the parties were domiciled in Australia and had abandoned the domicile of their origin, which is India, the jurisdiction of the family court at Mumbai was barred under section 1 subsection 2 of the Hindu Marriage Act. So in this case, the facts of the case were, and I happen to know this case because I was partly involved in this matter, so I can tell you. The parties, originally Indians, got married in India, I think somewhere Bangalore, Hyderabad or something. Thereafter they went and they took, I think, citizenship of, they became Swedish citizens, and later on they abandoned that or kept that and took Australian citizenship, etc. 2 children were born, etc., etc. There were issues between the husband and the wife came down to India. The wife was a daughter of a very well-known High Court judge. The wife came down to India along with her children, and she filed proceedings here in the family court in Mumbai because she was staying in Mumbai at the relevant point of time. When she filed this petition, the husband objected to it that section 1 subclause 2 of the Hindu Marriage Act talks about domicile, and we are not domiciled here. We have been living in wherever, Australia, etc., for a number of years. So Hindu Marriage Act is not applicable, and that is why the other act is applicable. Now on the point of domicile, the law of the land is, and I read so that I make no errors in repeating it, it says, in short, the act, in our opinion, will apply to the Hindus domiciled in India, even if they reside outside India. Okay? If the requirement of domicile in India is omitted for the sake of argument, then the act shall have no nexus with India, which shall render the act vulnerable on the ground that extraterritorial operation has no nexus with India. In our opinion, the extraterritorial operation of the law is saved not because of the nexus with the Hindus, but Hindus domiciled in India. Therefore, in our considered opinion, the act will apply to a Hindu outside the territory of India only if such Hindu is domiciled in the territory of India. It may be noticed that none of the provisions of the Hindu Marriage Act lay down the time and the condition when it will cease to apply. In other words, the provisions of the Act apply, it would continue to apply as long as the marriage exists, even for the dissolution of marriage. The Hindu marriage gives rise to a bundle of rights, obligations, etc. Therefore, the system of law which should govern a marriage should remain constant and cannot change with the vagaries, whims of the parties to the marriage. So they have stated Cheshire and North private international law, wherein the learned author at so and so says, it has been universally recognized that questions affecting the personal status of a human being should be governed constantly by one and the same law, irrespective of where he may happen to be or where the facts of a given rise, where the facts giving rise to the question may have occurred. The time at which the domicile is to be determined is when the proceedings under the Act are commenced. Is accepted, then every petition filed by a wife whose husband moves from one country to another for the purposes of the job or any other reason, he would be able to frustrate a petition brought by the wife by changing his domicile even between the presentation of the petition. The rule is once competent, always competent, and this will be so, etc., etc. I will not get into the rest of it. The essence of this is what is domicile as far as vis-a-vis the relationship in the NRI marriages. So this is what has been carved out. Now I am going to share with you a number of things. Number one, I dealt with a matter where this is both marriage and custody together, but I would like to, because the law of the land has been laid down and in two matters, and and I was fortunate enough to be a part of both the matters, and so with a little bit of extra knowledge than what the reporting would be, I'll be able to tell you. So in one of the matters which was there, parties were Hindus, got married in India, had a child born, a son born. So I think for 4 or 5 years they lived together, and there were certain disputes which were there. As a result of which the wife left the matrimonial home in Mumbai only and went to her parents' house, which was here in Cuff Parade. They were living at somewhere in Lokhandwala. She came to her parents' place in Cuff Parade. There also she found that the husband was troubling her, stalking her, getting the child, etc., etc. So she was advised that if she goes away to another country, he will not trouble her and do that. So she takes the child and goes to Dubai. After she goes to Dubai, she sets up a home there. She gets the child admitted, I think by which time he's 6 or 7 years of age, gets him admitted to a local school, and so on and so forth. Whilst this is going on, she's a little away from it, and thereafter, while this is going on, and she's a little calmer now because this man is not tormenting her, not stalking her, etc., etc. She receives what is known now, I don't know how many of you know, but in a Dubai court, you can file petitions under the non-Sharia law. So what happens is in Dubai, because there are a whole lot of expats which are there from India, Europe, etc., etc., and they live there. So they obviously, if they want to get divorced, they can't go back to their countries which is there. So there is a provision in the courts there, in Dubai courts, which are known as courts of first instance or trial courts as we call it, wherein every case that you have to file, whether you don't know whether it's going to be by consent or otherwise, you have to go to the court counselor. So there is what is known as a court mediator or a court counsel. Once the court you go, so you cannot file it in a court, okay? You have to go to the court mediator, say, I want a divorce from XYZ. Okay, he takes your name, there is all e-filing there. Thereafter, he or the mediator sends a notice to the other person. For example, your husband has filed a petition here, and you are called for mediation on such and such a date at such and such a time. That is when you are intimated about the fact that the husband has moved the court. But he has not really filed a petition, he's just intimated the court his intentions to do that. Now in this case, I'm coming to it, in this case, the husband went to Dubai and he went to the mediator, and the mediator informed the lady that this intimation is there, that there is a case filed against you, kindly come for mediation. The moment she learned about it, obviously she was panicking, why has he gone to the Dubai court, etc., etc. She contacted me, etc., and we filed a petition in India on the grounds, under the Hindu Marriage Act, on the grounds of cruelty or whatever those cases may have been, seeking rights under the Hindu Marriage Act. This gentleman goes to the, she didn't go to the mediator, she just sort of avoided that and filed a petition here. This gentleman, since she did not come, the mediator closed the file, that the other side has not come, now you are free to file. So he goes there and he files the case there. He files a case under the non-Sharia law, which is the Hindu Marriage Act, on the grounds of whatever cruelty, desertion, etc. And then the summons go to her. By which time our petition is also already filed here. I don't know the exact dates or the sequence. The petition is already filed here, and that has also been served there. Unfortunately, the system in India, we all know, and we are all lawyers, that there is nothing that happens very quick. Maybe the infrastructure, maybe the volume, maybe everything, and this has nothing to do with the lawyers and the judges. It is just to do with the way system is, because there is so much of volume. So once, by the time this gets numbered and etc., etc., he goes ahead and he moves in the Dubai court asking for divorce under the Hindu Marriage Act in the Dubai court, and simultaneously files for the custody of the child under Guardians and Wards Act. Now the situation in Dubai is Sharia law, non-Sharia law, but thinking complete Sharia. That I can tell you 100%. So you may be a Christian, you may be Parsi, you may be Hindu, anything, I'll say non-Sharia law, I will read the book, but my thinking is all Sharia. So the Sharia way of thinking was such that the father is a guardian of the child, and the boy, because this guy was a son, that he is the best guardian, and that is why it was there. So as a result of which, the pace at which they went, he obtained an order of custody for the son, who was then six and a half, and also tried to get a divorce decree which was there, whilst our petition was pending here. So what did we do? We filed in the India court. I think this will be very interesting for you all. We filed in the India court, that's in the Bombay Family Court, what is known as an anti-suit injunction, which you all have seen in the commercial suits. I mean, you always have it that, you know, you should not proceed in the other country because the jurisdiction of a commercial dispute is in, that you must have seen. So we filed under the, we filed for the anti-suit injunction in a matrimonial case in the family court which is there. So the family court in India, in Bombay, granted us that anti-suit. So always remember one thing, when you say an anti-suit injunction is there, the courts here don't pass orders against the other court. The courts pass in rem, as they call it, against the respondent who is a party to it. So you, the respondent, is restrained from proceeding in the Dubai court. They can't tell you, Dubai court, you can't proceed with the matter. You can't. There's committee of courts, you have respect for each other, you have to do all those things. So while this was passed, he challenged that order and went to the High Court, challenging the order. Unfortunately, the High Court overturned the order. And they said, no, the wife is living in Dubai, the child is in Dubai, the husband has moved the Dubai court, this is not a forum of inconvenience for her, you know, which is one of the grounds that women take, because that's a forum of inconvenience. Everything is convenient, why should it not be there? And let it decide. So we started yelling and telling the court that this is a very oppressive legislation which is there, it's a pro-men, pro-father, there is no concept of deciding custody matters based on the best interest and welfare of the child. It is just the age of the child and okay, X is given, Y is given. They don't apply their mind to the overall thing. How do the courts in India do? They'll see the father, the mother. No parent has an inalienable right. The courts are the ones who decide, who become the guardian of the children or the child, whatever the case may be, and decide what is in the best interest which they feel is a given set of circumstances. So there's a rule of law, there's a reasoning behind it, there's an examination of the facts and circumstances, there's also at certain times examination of the parties, people who are in the house who are interviewed, and counselors, etc. So there is a very systematic way of getting it done in our courts here, and that's why the family courts are here. But there it doesn't go. They say the Hindu Marriage Act, but this is what the whole thing is. Since the High Court order went against us, we went to the Supreme Court. Same, challenging what? Anti-suit injunction, that he should be granted, he should not. As an interim measure, the Supreme Court did pass an order restraining the respondent, the husband in this case, from proceeding in the Dubai court because this India court was seized of the matter, number one. And the same law is applicable. The parties are Indians, they are domiciled in India, they may be residents of Dubai, and all this Narasimha Rao, etc. What I told you, all those things were said. So they granted us interim relief, and they granted that stay of the order of the Bombay High Court, and that is how the matter was there. This gentleman goes to the Dubai court and tells the Dubai court that I am not asking you to proceed with the matter, because I can't say that, you do whatever you want. So look at how cheeky he was. So because I can't tell you, no, that please pass orders, please proceed, please take the next step, because I am restrained from doing so by the court. This is what the thing is, you pass order. Now if there was application of mind, the courts would have understood, but the courts went and passed orders despite a restraining order on the respondent. His plea was, when he came back to Supreme Court, I have not asked them. I just put your papers before them and I told them you do what you want, and they've decided to go ahead with it. So these are the things that happen. By the time it was going back and forth, everything happened. The matter got settled finally and the things were decided. So the Supreme Court passed orders under Article 142. There were a whole lot of criminal cases here, and it's one of the landmark cases which are there, and it finally got over. The child when he left was 5, when the decree was passed is 14. So that's how long the matter took, and that's where we are. So this was one of the matters which was there, where there was parallel jurisdictions of the court which were exercised. The another case which just came to me this morning, the husband is, who came to me, the husband is, he has a lot of startups that he has done in US, doing very well for himself and doing this. Met this girl who was working in Berkeley, got married to her, year and a half was there. There were some disputes which were there. They were married in India, the parents live in India, the girl's parents also live Mumbai, sorry, they live in Mumbai, the girl's parents also live in Mumbai, and after all these things he came. Now, again in US if you see, there is a different law for the West Coast, that is California, San Francisco, etc. There is a different law for the East Coast, that is New York, Boston, etc. and the other things which are there. Now, in San Francisco or the West Coast, if I may say that, but this case of San Francisco, there is a concept of what is known as a community property. So, community property is all the property acquired by the parties during the course of their marriage has a vertical split. Without examining how many years are invested in a relationship, who is right, who is wrong, etc. So if you see, for example, I don't know, many of you may be knowing or not, the Beatles star Paul McCartney, his wife of 1 year got hell lot of money from him by way of alimony because of this community property. So coming back to this, this is what the concept of community property is there. So the wife felt that it was advantageous for her to file in San Francisco. So she has filed in San Francisco, which was served upon him 4 days back, and through the process server, which I just explained to the process which was there, and that's how he panicked and he came down to India, and then he was there with me this morning. We have advised him that went through the petition which was there. The petition is on irreconcilable differences. I want a divorce on the grounds of irreconcilable differences. That's what the wife has said, and given a list of assets, etc., etc., that he had. The question that arises now is that if a decree is passed on the grounds of irreconcilable differences, that decree will be challenged by me here, because I just read out the law to you. That anything that follows from that decree cannot be held to be valid if the dissolution itself is not a valid thing as per the things which are there. So these are the mixed questions of law that will come up. They have not yet come up, I am just telling you. So what I have advised him is that before you leave and go back, let's file a petition here in Mumbai, because they got married in Mumbai. Let's file a petition here on the grounds of whatever cruelty or whatever is available. I don't know what the exact details are. And I said then you can go back, so that tomorrow when the courts are there and they talk about it, you can say that you have filed a petition in a court of competent jurisdiction, which is Mumbai, under the act under which we got married, and etc., whatever I have just told you right now which is there. Then they may ask, I have done a similar matter in which in the New York court they asked opinion about it, what is there, etc., etc. So now this cross-border jurisdictional issues is one of the main things that comes up in the NRI marriages. The reason I am giving you these examples is just to make you sort of understand it in a better manner rather than going very technically about it. So these cross-border issues are one of the basic hindrances which come in the thing, and the whole fight is about which court is the court of competent jurisdiction, which court is the court which is going to decide what is valid, sometimes to the disadvantage of the wife, like for this case which I am talking about. If the courts in San Francisco decide not to entertain her petition because of what the opinion is, then she is likely to lose that 50% which is there. But the husband is likely to retain that because of this law. So this law can come or is useful for both parties depending on the facts and circumstances of the case. Now what has happened is that after this, I have given this couple of examples. The recent trend which is there is that the Women's Commission or the crime against women, etc., especially in the north, and as I said, it's a very typical north concept of Punjab, Haryana and all those things, where the husbands get married, they dump the wives, go back, and whatever happens, and the rest thing is there. So now there is a movement which is going on within the Women's Commission to ensure that there is some kind of a deterrent for such husbands who cannot get away by dumping the wife here and depriving her of her legitimate dues, etc., etc., which is there. So there is a proposal which is doing rounds in the commission whether we should, next time they come to India, confiscate their or impound their passports, so that they are, sort of, there is some kind of a deterrent, because they want to go back and they want to earn. So if you put that kind of a thing, that will at least ensure that the women get a little better deal in this entire thing than rather than left to this. Because sometimes what happens is, even if the India courts gives you a decree of maintenance or alimony, your difficulty is how will you execute it? You don't want to live with a decree, you want to live with the execution of the decree. Then how do you get it done in a US court or in the US jurisdiction or UK jurisdiction? What is the process there? Now, it's not that all of them are savvy as you and me and understand how to go about the whole thing. So that's to take care of such difficulties that come up. That is the reason why the Women's Commission and the Crime Against Women cell in Delhi is deciding to bring all these things which are there. So the concept of, it's a new concept that has evolved after the passing of the Act in 1955. Obviously this was not envisaged by the courts, by the legislators when the Act was framed. And it was only subsequent due to the judicial legislation, if I may say so, wherein when the courts have come to the rescue of such people, laid down the law to govern about marriages, etc., which are governed by the Hindu Marriage Act, which is a court of competent jurisdiction. Another issue that comes up in most of these cases is cross-border custody issues, because which is the law which governs the custody? Now, I'll give you an example. My client, she's a mother, she is a Swiss Geneva, so she's a Swiss national, and they were married in India, they're Muslim, they were married in India, there are 2 children born. There were certain disputes which were going on, as a result of which the wife and the 2 children were living in Geneva with her parents, and from 2013 to 2018 there was there was separation, no legal proceeding, husband would come and meet the children would come and spend holidays here in winter and things like that, and things were going on. Now this August or September, they had come down for their summer vacation, because their summer is July, August, and they were to go back to Geneva. The husband did not send them. He just kept the children back and he did not send them. So obviously she panicked, she came back here and he did not give her access, did not do anything. So she came to me and then she said that, can I go back and get an order? So we said okay. She went back to Geneva and got an order from the Geneva court saying that the children are the wards of this court and we are the ones to decide. They have been uprooted from the familiar surroundings and the school and etc., etc. It's against the interest of that. So we order that the respondent, this was an ex parte order, we order the respondent husband should reinstate the children back, and whatever the matrimonial disputes can be settled later on, but the children should not be settled. Now what the husband has gone and done, he has gone and filed a petition in India, in the family court, saying the children are with me, now the children want to be with me, kindly give a restraining order that these children cannot be removed from my care and custody. So there is an order of a Geneva court which says children should come back. There is an order which he has obtained that the children are living with me, they are under my care and custody, he should not do. Now what the courts are going to do, God knows. Because both the courts are going to say, I have to respect this court's order, I have to respect this court's order. Now what is in the best interest and welfare will have to be decided by this court if they feel that, forget what the order of the Geneva court is, but if the children were in a particular thing, and there the difficulty was the medium of instruction there is French, and here when he got them admitted, there is no, it's English. So the child who is 7 and 9, they're struggling with the language, obviously, because they have been born and brought up and they've been tutored only in French, which was them. So I really don't know how the judges, I don't know how will you decide this matter if I put this before you as a judge. Whom should the children go to? What is your take?
They're born and brought up there.
Well, not really born and brought up. They were born and brought up here. But since 2013, as an internal arrangement between husband and wife, because they were having disputes and to keep the children away, from 2013 the children have been living in Geneva. For last 5 years. No, it's 2018, yeah.
But they got married under the Indian law and married in India.
I'm not on divorce. I'm on custody. Who should get the custody?
What was the contract between the two?
No contract, just an oral understanding.
Oral understanding.
They are
over a
Muslims.
period of time.
Sorry?
Overall understanding over a period of time.
No, nothing like that.
When you said from 2000.
No, I'm giving you the time frame that how the children were there from 2013. So there is no such contract, no such understanding, no such email that the children will be there only after 5 years, for 5 years, then we will review and come back. So it's an open-ended understanding, again no written contract.
Okay. It was an understanding that the children would come here once a year during the summer, 2 months. But this had been going on for 6 years.
5 years, yeah. 5 years.
5 years. And then the children are sent here with the understanding that they will be sent back to Switzerland.
Absolutely. And they have a return ticket also.
In fact, kidnaps them.
It's a father doesn't kidnap a child, no?
Your client, so you will feel
He is not my client, she is my client. But still I cannot say that the father abducts a child. If you take the child, you are guilty of abduction. But the father is a father.
But
Because in this instance, under Muslim law, the father is the natural guardian.
Okay. The twist to the story is that their parties, though both are Muslims, got married under the Special Marriage Act.
So what if there was no different designation?
Huh?
In your case, what if there was no twist? Like you said just now.
If it was not the Special Marriage Act. Yeah, but even under the Indian law, even under the Indian laws of guardianship, the issues of custody or care is decided in the best interest of the children. Now, as she is my client, and if I were to plead her case and you guys were the judges, I would say the children are doing excellent for the last 5 years because I've been single parenting them. They're doing and which is a documented record. Education, wonderful. Extracurricular activities, wonderful. Environmental surroundings, Geneva and Mumbai. Breathing fresh air, okay, that's there. They go skiing once a year because they are in Switzerland. They learn piano, they learn guitar, they are into football, the boy is into football, he is doing tennis, and everywhere the children are doing very well. They have their friends there, they have their teachers, everything is there, and it's very hunky-dory there. Okay?
It is so natural to just be acclimatized to the surroundings.
Perfect.
It is so natural because they are children, so they will obviously like it there
Huh.
because they've been there for 5 years.
And they are doing well there, huh? Not only liking there. Their parameters, health-wise, education-wise, other activities-wise, they are doing very well.
What is to say that if they were living with the father, they would have not grown so well? I'm just trying to understand that if there is a law which has been an order which has been passed by that country and an order which has been passed by my country because the husband has chosen to file a petition here, how does it work for us?
So my question to you, I will tell you how it works, but my question to you is, as the gentleman rightly stated, he used the word kidnapping, but the legal word is parental abduction. Okay? So if there is a parental abduction by the father, should you be rewarded for it?
Whom? Should rewarded the father?
Yeah, that giving the order that okay, the children cannot be removed from you.
I'm not even going there. I'm just saying your defense was that I have given such a beautiful.
No, my defense is if the best interest and welfare of the child is the only paramount guiding consideration for the courts to decide the custody. These are the documents, these are the pictures, these are the therapist's reports, whom the children, therapist means the counselor. And yeah. Now, is it important to understand a child's interest no, hear me out, in view of the fact that they are 9 and 10? If your child tomorrow says, I don't want to go to school, my wish is I don't want to go to school, my wish is to sit and watch television, my wish is to get up at 12 o'clock and eat only junk food, my wish is only to play and not to study, would you take care of the wishes of the children? No. No, it is a lifestyle. I'm not talking about a material thing, I'm talking about a lifestyle. Getting up late, eating junk food, not studying, doing all these things, a lifestyle. Okay? Today, the question that will come before the court, and I don't know what the courts are going to do, but I'm so glad that there is so much of brainstorming that is happening from both ends, which is there, is if the courts are to decide the best interest and welfare of the children, then under such circumstances, all these, I'm telling you the law, not because they are my client, all these factors have to be considered. You are right. One of the factors will be the wishes of the child, but if there are 10 factors which are considered, 9 are weighing in them being there, and 1 the wish of the child, unless the child is tormented, oppressed, and he is depressed and he is gone into something, which are extreme circumstances, but I am just giving you to draw home the point, then the 9 outweighs the 1, because the 9 factors are in the best interest of the child, though the child may not want to be there or his wishes are not there. That's how the courts decide. See, it's a very difficult job for a court. It's very nice for us to sit and talk. But suppose if you are sitting, I am convinced what the father is saying, I am convinced what the mother is saying, I am convinced what is best interest, but then I am alienating the child. I mean, ideal situation, father and mother come together so that the child has the best of both the worlds. But that's not practical. It's not possible because there is too much of water that's flown under the bridge. Then what is the way to go about it?
I just have a doubt. In this particular instance, you have to please both of them are valid.
Sorry?
In this particular instance, you have 2 orders and both the orders are operating and valid. So,
Operating, yeah, both the orders are ex parte. One more thing. The Geneva order is also ex parte in the interest of the children. The Bombay order is also ex parte. So you are armed with 2 ex parte orders.
So how does it work at that point?
Now on this point I can't tell you because that's sub judice.
Why I'm asking you this question is, I believe that if you are a signatory to that country, I'm just asking you.
No, so India is not a signatory to the Hague Convention.
It's not.
No, it's not.
In the process,
It's not.
Which country?
It's in the process.
Okay.
Hague, H-A-G-U-E. Huh. So India is not a signatory. So the India doesn't want to, because if India becomes signatory to the Hague Convention, then what today the mothers are doing of abducting the children from US, create US born. So there is another case, but I think Rahul is going to yell at me, my time is over. He had told me 45 minutes. I'm sorry about it, but this is what happens. We start talking on subjects which are so close to our heart. So there is another incident, I think it just slipped my mind. I'll come to it. Sorry, you were saying something, ma'am?
I have a situation which is somewhat very similar to the case that you gave, which might ring a bell to you as well. What if there is a situation where the child who is a minor living with the mother very happily, and if there is, for a couple of years, say, the mother is living abroad, both of them are married in India, but there is a situation of a parental abduction, and suddenly...
So you mean the child is abducted by the father to the US?
Yeah. And there is, if let's give the child a question saying that, okay, you tell us who you want to live with.
Age of the child? Age of the child?
He's a minor. As
No, children are all minor only, but age 0 to age 18. So no, why I'm asking you is,
10 to 15.
okay, so then which is where his wishes will be considered?
Yeah, wishes will be considered. The child, I would like to quote again, the child is living very happily with the mother. But the one night that the father abducts and takes him back to where the father is living, the child changes the statement saying that I do not wish to live with my mother because my mother is not taking care of me.
Absolutely.
To the best of his health.
Absolutely.
So where does the benefit of doubt lie?
So the benefit of doubt lies in the fact that yes, the father has tutored the child in this situation which you are describing to me. The child is tutored. So there are 3-4 things that happen. Either the child is tutored, the child is emotionally blackmailed, or the child is threatened. Threatened. So under any of these things, how is it emotionally blackmailing? I'll tell you. Suppose if I am the mother and the court order is there that I should give access to the father. I don't want the child to see the father. Okay? But child doesn't mind, the fight is between husband and wife, the child doesn't mind meeting the father, having fun time, having ice cream, going for a drive, going to all those things. But I don't want to see because I have an axe to grind with him. I will ensure that you don't see the face of our child. That's my punishment for you. So there are people with such mindsets, you have to understand. So how do they do? How do they operate? How do you convince your child? If you go, and this has happened, I'm not saying it's not fiction, it's something which I've heard and which I've seen. If you go to your father, I'll jump from the 7th floor. Now you tell me, a 5 or a 6-year-old child is told by a mother. So number 1, child is torn between the 2 parents. He loves to stay with both the parents, he is not given the choice. Okay, his mother is there, great mother, taking care, doing everything which is there. But with this one kink in her mind, I will not let you see the child. And then she says, if you go and meet your father, you go, I'm not stopping you. then I will jump from the 7th, and this happened, I'll jump from the 7th floor. The child is traumatized, petrified, and when the father comes to pick the child, he says, I do not want to see you, I don't want to go to you, I don't want to be with you, and starts howling, crying, yelling, screaming. The father is saying, what happened? 6 months back before we separated, the child was so friendly, he has all pictures, he has all videos, blah, 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 showing what has happened. And then the mother says, I am willing to send, let the go. You take the child, see if the child is going, I have no problem. But is the child going to go when this is there in the back of the mind? So I am giving you an extreme example. I am not saying this is a very common thing. This is an extreme example I am giving you to draw home the point that how the wishes of the children could be guided by certain, which he raised a point, could be guided by fear, by trauma, by blackmail or any other things which are there. So are the wishes of the children free, frank and without coercion, undue influence? That's something very difficult for the courts to find out. So in our courts, in the family courts here, and I am sure in most of the other courts also, they have a whole infrastructure where you have the child counselors. There's an organization called Muskan in the family court. That organization Muskan is only to counsel such children who show either extreme range of emotions, hatred and things like that. Because ultimately a child cannot survive this long. If he has to be a healthy child, then the child has to have that emotional balance. As they say, IQ, intelligent quotient, EQ, emotional quotient is equally important for a child to grow, which is where I believe counseling to the parents is more important than counseling the children. You have to, and that is a duty of every good lawyer. Your client may come and say, ma'am, I am willing to give you, cut a check of whatever amount you want. Please ensure that you, and they come to me, please ensure that my husband does not see the face of my child. I say, thank you very much, you can take this back. And I am not the person who is going to do this. I am a person who is going to ensure what is, or to the best possible this thing, to explain to you how it is important for the child. Unless there is an extreme case. Now in one case when my client came to me, please ensure that he doesn't get, because my husband was in the rehab, he was a drug addict, alcohol, of course. Then you must come to the rescue of such things. Because you can't let the child be exposed to certain things. When he goes to the father, there are drugs lying around, alcohol bottles lying around. That's not the way you want. So these are extreme circumstances, and which you have to be very firm about it. But otherwise, to ensure that I'll cut a check of whatever amount you want, but ensure he doesn't see the face of my child, is not a trait that as a good lawyer you must allow it to happen whatever you get. Because you have a responsibility towards the society and the child. And the responsibility towards the society and the child is to give a correct, guided advice to make that child a better human being when he grows up, rather than catering to the negativity of the woman makes him a mixed up and messed up child who grows with prejudices, hatreds or his own things which are there. So as lawyers who practice family law, there is a great amount of responsibility and duty cast upon you to guide in a manner which is to ensure that at least the child, to the best possible way, is kept away from the, as they call, the blaze of the matrimonial disputes, and you ensure that he is given that comfort. So that's where it is. So I think my time is up, more than what I was supposed to be there.
One question.
He is the boss, ask him. Salil, 5 minutes. Because, but you know, which is yes and no, but there is a treaty, India-Dubai treaty, if you see, in which these treaties are sort of, you know, things which are there. When you come for the enforcement of a decree, say for example a money decree or for example a restitution decree, the process is going to be the same. You have to file it, you have to give notice to the other person has to come. He may say that, okay, I have challenged that decree in some higher court, so then the courts will say, sorry, we can't end.
Already challenged by High Court and High
Yeah, so whatever, then they may say that you go and execute the decree in the court in which has passed, because we cannot do anything beyond it if he is not submitted to the jurisdiction over here. Because even the husband should submit to the jurisdiction here, no? If he's got a decree there. That's where it is.
Then it has no value then.
So it's not a question of not having a value. The question is you are armed with a decree which will help you to further file proceedings here, and that will support you to get that. But if you ask me, will it by itself help you? Probably not. So like for this Geneva matter which I was telling you, the mother has filed a custody petition here. Though she's got an order from that court, because where do I execute that order? I need to have some petition before me, and the only before the court, sorry, and that petition is going to be the custody guardianship petition, in which we can show that how the immediate return of the children to Geneva is must in the best interest of the children in given facts and circumstances of the case.
So here also whatever the petitions are having a pending for the restriction of the conjugal rights, in that itself would be a show that
Yes, that there is a court of competent jurisdiction which has passed a decree, which will strengthen the hands of the court to pass it, because one court has gone through it and given you the order. Though they will follow their own process also. Zala, that's it?
Any more questions?
I wanted to know, we stopped you halfway through regarding countries who are signatories to the Hague Convention and
Yeah.
how it is misused.
So misused.
Yes, you.
So no. So what happens is, like, for example, India is not a signatory. I'll tell you what. I was giving you an example. My clients, both of them are doctors, based, original Indians, got married in India, went to UK, both are very successful doctors, UK citizens, child born to them, British UK citizen again. The child was 2 years old, some problems happened, and the wife moved out from their marital home and took up, because she's working in UK. AC band karta thoda? Band. So she went to UK, she shifted to another place. When she left the husband's house, the husband's solicitor sent her a notice that you cannot remove the child outside the court because we are going to move the court. The child is a ward of the court. The moment she got that notice, or whatever the solicitor's notice, she came back to India with the child. And she filed proceedings in the Bombay Family Court for divorce, for custody of the child, for everything which is there. Now in UK, when a solicitor's notice goes, it's as good as receiving the court's notice. US also. So he went to the court and he said, this is what it is. The courts were very furious for her act, and they passed an order that the child, the court's order, British court order, the child is a ward of this court and the child is ordered to be reinstated back in the same surroundings, etc., etc. Now, armed with this order, the husband came to me and we went to the court to show this and these things which are there. By the time maybe the husband contacted me, or by the time he got the order or whatever it was there, the wife had already obtained an ex parte order, rightly so, and I would not say no. The child was 2.5 or 3 years of age, that the child cannot be removed, and that because it's a 3-year-old child, the interim custody and the guardianship be granted to me. In India, in Mumbai, yeah. So she has a custody guardianship order here by the court. I have a ward of the court which is as good as a guardianship order, and now I come here to execute that. Now the courts are saying, no, we've already passed this order. Now we can't let the 3-year-old child go back, because as per the law in India, a child below the age of 5 or 6 has to be necessarily with the mother. So we cannot do that, so we have to go through this entire thing. So even if we were, because we are not signatories, we cannot execute the UK court order here, because India is not a signatory to the Hague. If it was the other way around, that if India was a signatory, then they could have executed that order because we are signatory to the Hague Convention. So that's what I was trying to tell you.
So there is no solution. Just wait.
So the one who has the child gets the candy, as they say. So your orders, your courts, your observations, sometimes I wonder as a lawyer whether they really matter. You know, as lawyers we study so much, we argue so much, we get so orders, we say, yes, I've got the order. But are getting an order and getting the child, or getting the order and getting the money, a huge difference. So thank you very much. Thank you very much for patiently listening to me. Sorry? Yeah, you can take my number from Rahul and then I can do that. And apologies for keeping you waiting. And thank you. And I was very happy to have such an interactive audience also. Thank you very much.
Wonderful information with us. Thank you. I'm requesting Rahul sir to felicitate our guest. Request madam to write in our book as this is our visitors.
Of course. No, I don't have it.
By the time madam is writing in book, I would call my colleague, Advocate Prathamesh Iyer, to give vote of thanks.
First of all, I would like to thank our founder, Rahul sir, for giving me this opportunity to give vote of thanks. On behalf of Team Hammurabi Tablet, I would like to thank our today's speaker, Advocate Mrunalini Deshmukh, for enlightening us on today's topic, that is scope of practice in NRI matrimonial disputes. I would like to extend my thanks to our cameraman Uday and Mr. Videography for his valuable assistance. And most importantly, I would like to thank you all that you continuously supporting us, and keep your support like this and keep loving Hammurabi Tablet. Thanks a lot.
Now I'll just announce our next program. It will be on 19th of January 2019 and 19th of January 2019, and we will be now shifting the venue from here. We will be conducting program in the Indian Merchant Chambers, that is IMC, second floor. And the topic now, in fact, we are shifting our focus slightly from guidance segment. If you analyze our 29 programs, mostly you will find scope of practice. But now we are shifting to the actual deliverables. So now we are starting with how to concept. So the first is how to draft an RAD suit. And what are the basic ingredients? What should not be there? What should be there? And for this, our guest is a very senior lawyer from Small Causes Court, Mr. M.N. Kenia. He is also called Mauji by Kenia. He is a very senior lawyer of Small Causes Court. So he will give us tips on this, that how do we draft. So this is actually Hammurabi is shifting its base. From scope, we are now coming to your actual utility base. That what you want, you should get the thing which is needed for you in your practice. So now from 19 we have shifted our base. That we will go with this series. How to draft RAD, how to draft testamentary, and lot of things. Of course, I will keep on announcing it, but now it will be how to. Scope is now finished with 18. Plus, on next Saturday, we have INN student advocate, and that will be done by Advocate Maulik Chokshi. That program is done at Malad, Sage Plaza. Those who have given their numbers will get WhatsApp for that. And since there are some more new faces, I always say that whoever are either the advocates or who are the students, because we have two programs. On every second Saturday, I have a program in my office called I Enhance Student. So there a law student is called, he selects his own topic and delivers a small lecture for 45 minutes. So this is with the intention that a student right from his college days should start getting this habit of reading, getting the courage to speak, cultivate a knowledge. And similarly, third is this program. Fourth is I Enhance Advocate. And the advocate who speaks there is compulsorily has to be less than 5 years. Above 5 years, we don't take it. It has to be less than 5 years. So it is that Maulik Chokshi, and his topic is overview of 5 major heads of income connected with income tax angle. So he will be speaking on that. Of course, every program is recorded now, so you can see that on YouTube also. So whoever are interested may please contact and tell us that he wants to be a part of either, if he is a student, he wants to be INN student. If he is an advocate below 5 years, he wants to deliver a lecture for INN's advocate. And once again, I thank you all. And now I take this opportunity, because it's a classic coincidence. It is because of Madam's donation that we could book 1 year of IMC. No, because I am not any registered association. We are not registered association. It was the pure faith and a good act on part of Madam. And we utilize that for booking 1 year IMC. So for 1 year, we will be there in IMC. So I take this opportunity. Thank you, Madam. It was really nice. Jana Gana Mana Adinayak. Thank you everybody.